day and welcome to the Law Lab. Here we dissect and unpack everything legal. Today our topic, or what we are about to treat, is on how to brief a case. That is the case briefing methodology. Just as any time that you read a storybook and your friend, your colleague, your brother, your sister asks you to summarize whatever thing you've read in the storybook, you try to capture every logical thing that you read and not necessarily tell them exactly what you read, but substantively what the story was telling. You try to summarize and tell him or her. That is the same way that applies in the legal system. Here we put certain measures because you know the number of pages of cases by jurists and others are quite many, and that no one will be able to read and capture everything in his or her head. And so what we do is that we find a way to brief the case to help us understand it, so that when your colleague, your friend, your boss, whoever your tutor asks you, you could clearly and simply, within some few minutes of reading some 57-page ruling or judgment, you would be able to summarize and give him actually what the case meant. But before that, I have a piece of advice for you. Mostly when people enter into the law faculty and start to read law, they have difficulty in appreciating the law quite early. This is because the law is entirely different from other areas we've been learning, being it political science, being in the sciences, being it in the arts and other areas of study. The law is entirely different. The law is entirely different. But just as I mentioned, an advice is an advice. It's not binding on you to take, but if you read or if you listen and appreciate it, it may be of help. Just as the court said in the Ghana Bar Association versus the Attorney General and another on determining the validity or the essence or the legal effect of advice given by the Judicial Council to the President on the appointment of justices, the court clearly stated that advice is advice and it is not binding on the President. Just that the President ought or need to listen to that advice and make his decision. An advice is an advice. Speaking to colleagues, getting to know colleagues, learning the law myself, I've come to appreciate that when you are learning the law, you need to go through 3 strata or 3 stages in order to be able to appreciate or know the law. First, you can't pick the law book, read it at the first instance and feel that you've learned it. No, it doesn't happen that way. Remember, I am still stressing on the point that it is an advice I'm giving. Well, I believe that the first stage of learning the law is comprehension. It's comprehension. It's comprehension. You need to comprehend whatever thing you are being taught. You need to comprehend whatever thing you are reading first. And the second stage is appreciating. You appreciate whatever thing you've read or you are being taught. You comprehend, you appreciate, and the third stage flows naturally or organically. That is the learning bit of it. You first comprehend, you second appreciate, and the learning follows. I'm saying this because during our time, reading legal systems, one of our lecturers made us read Article 140 of the Constitution, Clause 3. Article 140, Clause 3. It is on your screen, and you could clearly see. I would want you to just give me your clearer understanding of this clause, Article 140, Clause 3. Your first understanding after reading it in the comment section. In the next section of our videos, we will discuss it, and you appreciate that in learning the law, you must first comprehend, appreciate, and the learning organically follows. Now, let's look at today's topic, case briefing or case brief methodology. Case brief methodology. When we mention case brief, it is not a hard and fast rule that you must follow this technique I am going to give you. However, anytime you are briefing a case, you need these elements to be present. I am saying it is not hard and fast because it is dependent on your tutor, it is dependent on your teacher, it is dependent on your school or whoever is demanding the case brief from you. That will determine what approach you use. Some people allow you to use your own approach in briefing cases. Others also give you their specific approaches they want. But today, what I'm giving you are some major elements or some major criteria that you need to consider anytime you are briefing a case. So just as it's rolling on your screen, we'll be going through the case title. Move to procedural history. Move to material facts. Look at legal issues. Look at argument of parties. We'll look at the holding of the court. And also look at the ratio decidendi and also the obiter. Then the commentary aspect is what you personally think of the case after reading the case. I will pick each subheading and speak about it and explain why it is necessary that you capture such subheading or such heading in your case brief. I'll start with the case title. Nobody can tell you a story without telling you the title of the story. The title of the case is of much essence and importance because anytime I want to cite a case, I need that title. I cannot just come and tell you that, Charlie, have you read in a decided case, so and so? You ask me the title of the case. So the example rolling on your screen would be our example for today. The most popular case of Tufo versus Attorney General, 1980 Ghana Law Report, 637 to 667. Tufo and Attorney General, 1980 Ghana Law Report, 637 and 667. Now, when you pick the case title, I would want to expatiate on it. The first name you see is the plaintiff. The first name you see is the plaintiff. And the name that comes after the V, the capital V or the verses, is the defendant. That is when the case is starting on the first or the trial court, the first court of instance. That is the plaintiff defendant. When you move to an appellate court, we have the appellant and the respondent. That is how it goes. The first name you see at the trial court is the plaintiff, and the other name on the other hand, the other party becomes the defendant. Get to know this. We don't write first names. In case title, we don't write the first names. Mostly we stick to your surname or your last name. It is why you see Tufo, because clearly if you know Tufo, he's called Dr. Kwame Tufo. I think there is another name I'm missing out. Dr. Kwame Tufo. He is of blessed memory now. Another thing you need to understand is that anytime the parties on the plaintiff side is more than one, so let's say I have Tufo and say Mensema, Tufo and say Mensema. In order to prevent writing Tufo and Mensema, which will be long, I will just write Tufo and another. The another can be shortened as ANOR. So Tufo and ano, meaning that Tufo and another party he went to court with as plaintiffs. Imagine that there are 3 plaintiffs or more. Let's say Tufo, Mensema, Asana, and Anne-Marie, 4 plaintiffs. I decided to make another. What then happens to these 3 people? Am I going to write all of their names? No. What I'm going to do is that I'll just put Tufo and others. Tufo and others. Tufo and others. And the others can be shortened as ORS. So anytime you see ORS, it means others. Anytime you see ANOR, you mean another. When you see the normal bracket or the round bracket, it is the year in which the judgment was given. Mostly, what then follows is the portal that published the case. The portal that published the case. Anytime you see JLR, it is Ghana Law Report. When you see SCJLR, Supreme Court Ghana Law Report, and other forms of law report, we have the West African Court Law Report and others, the WACA amongst others. Mostly when the said law report in that year is publishing, let's say 2 editions of that law report, they put the figure. So maybe if, say the Ghana Law Report in 1980 was publishing 2 editions and say the Tufo and Attorney General should be in the 2nd edition, you would have seen 2JLR. And then after the law report, there follows the page number you can find the case upon opening the law report. So that is it for case title. I said that first you deal with the parties, and the parties, when it is at the first court of instance, you deal with the plaintiff coming first and the defendant coming after the verses. Remember, we mostly keep it short by putting your surname or your last name. We don't bother using your first name, else it will make the case title so long. After that, you look at the year in which the judgment was made or the judgment was published. Then you move to the law report and also the page number you would find. The second stage you need to look at is the procedural history. The procedural history. The procedural history. A case that comes in mind is the contract case of P.Y. Atta and Sons versus Kinsman. P.Y. Atta and Sons versus Kinsman, as you have on your screen. Clearly, when you read P.Y. Atta and Kinsman, you get to know that the case traveled from the High Court, moved to the Court of Appeal, and then ended up in the Supreme Court. Please, as a law student, it is an error. It is an error, an unforgivable sin to say appeals court. Do not say appeals court. Say Court of Appeal. So the case traveled through all these courts. So anytime you are briefing such case, you need to make whoever that is going to read your case much aware that the case traveled through, or the history of the case, moving from, say, the High Court to the Court of Appeal and ending up in the apex court of the land, that is the Supreme Court. Our next element or next subheading we will be treating is the material fact. The material fact. The material fact. Anytime you see, when you talk of the material fact, there are a lot of facts presented in the case. It is not all the facts that you need. Imagine you are telling your friend a movie that you watched. You don't need to tell that friend of yours that when they were starting the movie, you saw the names of the cast and others. You tell your friend substantively or substantially what actually ensued in the movie. What actually ensued in the movie. And so it is not all the facts that you need to put out or tell your friend. In similar vein, it is not all the facts that you need to tell or you need to put on your paper. All that you need is the material fact. And this is the simple trick. You are looking at the facts that led to generating the legal issues in the case. So mostly the trick is that people jump this point and look for their legal issues first in the case before they are able to extract or espouse the material fact. Your material fact must correspond directly or mirror the legal issues. It is the fact that surrounds the legal issues. I'm repeating it again. It is the fact that surrounds or generates the legal issues. Now, let us move on to the fourth element or the fourth subheading, the legal issues. Everyone rise up in the morning and has issue with one person or the other. Charlie, me, I get issue plus you. This one, I get issue plus that. No, that is not the type of issue we are looking for. We are looking for the legal issue. the contention within the case that can be resolved by a law. If there is a contention in the case and it cannot be resolved by law, it is not a legal issue. So when we talk of legal issues, we are looking at the contentions in the case that can be resolved by using the law. And so it is out of these legal issues that one can extract the material facts of the case. I think I've mentioned that already. So anytime you find a contention in the case and you cannot find any legal or applicable law to resolve that legal issue or that issue, it is not a legal issue. It is only a legal issue when there is contention and there is an available applicable law that can seek to resolve it. Now, the next thing you need to consider in briefing a case is the argument of the parties. The argument of the parties. Just as I've mentioned under material fact and legal issues, all that we are looking at is the arguments the parties have placed on the legal issues. Not any argument that is outside the material fact or outside the legal issues. We are looking at the argument of the parties on the legal issues or the contentions that can be resolved by an applicable law. So those are the legal issues. So let's say you had, those are the argument of the parties, sorry. So let's say you had 4 legal issues in the case. You should be able to give out or state clearly the argument of the parties on each legal issue. On each legal issue. You should be able to state the argument of the parties on each legal issue. Now, the next thing we need to understand or know is the holding of the court. When we talk of the holding of the court, it is a simple yes or no answer the court gives out to the legal issues. So one thing I left out you need to know under the legal issues is that anytime you are raising the legal issues, it's become a judicial jargon that we go by, or a prefix to every legal issue we raise. We mostly prefix our issues with whether or not. Some people simply keep it as whether, and it depends on the writing style and the preference of your lecturer. So whether or not so and so. Do not in any instance use can, C-A-N, in your legal issues. Do not in any instance use can in your legal issues. Note, everyone can do anything provided the person has an opportunity. You don't raise a legal issue using can, because the possibility of anyone doing anything at any point in time is possible. We are looking, as I mentioned, the legal issues, we are looking for the legal contentions or the contentions within the case that can be resolved with an applicable law. Now, the next thing we will be looking at is the holding of the court. Now, I said the holding is a yes or no answer to the legal issues you've raised. So when you look at the argument of the parties on the legal issues, you should be able to now extract the holding of the court, whether the court is responding in the affirmative or otherwise of the legal issues you've raised. So it's a simple yes or no answer you are given. Now, the most important bit of the case, or in the case briefing, is the ratio decidendi of the court, or the reasoning of the court. The ratio decidendi of the court, or the reasoning of the court. Now, in our common law jurisdiction or common law setup, we adhere to stare decisis, which we all know as the precedent form. This is due to the hierarchical system of our courts. It has become part of our legal system to follow precedent. So anytime that we are looking or we are dealing with a matter, all that we look at for is the reasoning of the court. Because when we get the reasoning of the court, it becomes a precedent that subsequent cases which has similar facts would rely on in or would rely on in adjudicating such matters. The court will rely on such precedent in adjudicating such matters. Now, the ratio decidendi has three composition. First, it looks at the material fact you stated, and the second, it applies the applicable law to the material fact. Then you get the ratio of the court. First, the judge or the court will consider the material fact, apply the applicable laws to the material fact, and then you get the ratio or the reasoning of the court. It is the most important bit of the case that each and everyone or any person reading the law is looking out for, because that is actually the determination of the matter. So where the judge or the court looks at the material facts and looks at the applicable law, apply them together, and the person gets or the court gets the ratio of the case or the court. That is the ratio of the court. And so that is the most important bit of the case, that anytime any of your tutors, any of your friends is asking you, Charlie, what is the principle or the ratio of the court? Simply, the person is demanding from you the material fact plus the applicable law, with applicable law being applied to the material fact for you to get the ratio of the court. Just as I mentioned early on, that we are looking at the material facts, there are other facts that are not related or that are not needed in determining the matter. In the same light, anytime the judge applies the applicable law to the material fact to get the reasoning, some of the judges even go beyond that to give their own opinion and others. Those that are not part of the ratio of the court is called the Obiter dictum. In our normal pidgin setting, some may say it is non-fact because it is not part of the ratio of the court. It is additional information the person is given. But note, some of the Obiter dictum or Obiter dicta we see do have persuasive effect, and sometimes it even goes beyond time to become the position of the law. In our subsequent videos, we will find cases that the Obiter given by some judges has gone beyond the Obiter status and has now become the ratio of the court or the ratio in the case. The last thing you'll be doing under case briefing is the commentary. This is after you have read the case, gone through the procedure, gone through your material facts, raised your legal issues, talked about the argument of the parties, looked at the holding of the court, speaking to the ratio of the court or the ratio decidendi, looking at the obiter. Now you are personally going to give your comments about the case, how you feel the case went, whether it went well considering the applicable laws or how the judge ran around it, whether you agree or disagree with the ruling of the court. And that bit, it is for you. We call it the freestyle bit. But note, anytime you are freestyling something, note that you are bringing something constructive to the table. Not that you are freestyling and you say the judge was just emotional and be writing certain things that is not really relevant or sometimes insulting to the judges who actually adjudicated on the matter. So today we've looked at case briefing methodology or the case brief methodology. And we started by appreciating the fact that it is not hard and fast. It depends on your school, depends on your tutor, it depends on the person directing you to brief it. If a person gives you a certain formula or a certain way you have to do it, you need to go by that. However, what I'm advising is that these elements or subheadings or subtitles need to be captured. First, we looked at the case title, where we looked at the case of Tufo and Attorney General as an example. And as I stated, first, we will deal with the names of the parties with using their surnames and not their first names. Mostly the plaintiff comes first and the defendant is on the other hand. When it moves to the appellate court, it is an appellant versus the respondent. And one thing you should know is that when it is on marital matters, we bring a petition. So the person becomes the petitioner and the defendant and the petitioner or the respondent. When it is an election matter too, it is a petitioner and the respondent to the matter or the defendant to the matter. We said that the year that follows the names of the parties, when it is a square bracket, we are talking about the year in which the case was published. When it is a round bracket, it is the year in which the case or the judgment was made, followed by the law report and the page numbers. We moved on to talk about procedural history, where we stated that when we look at procedural history, we are looking at the length or the journey the case has been through. And in the case of P.Y. Atta and Sons versus Kinsman Enterprise, as an example, that case traveled from the High Court, the Court of Appeal, and to the Supreme Court. You need to state that for whoever who has tasked you to brief the case to know the journey in which the case has been through. Note, I warn you that it is an error and an unforgivable sin for a law student to say appeals court. We say court of appeal. Then we move on to the material fact. I said the material fact is being sourced from the legal issues you generate or get from the case. Material facts are sourced out of the legal issues that arises in the case. And now, when we talk of the legal issues, we are looking at the legal or the contentions in the case that can be resolved by an applicable law. The contentions or the issues in the case that can be resolved by an applicable law. Note, I warned you that you never in your life should you use can, C-A-N, in raising an issue, because every individual in this world is capable of doing anything. Any person can do anything at any point in time. I also mentioned that it's become a legal jargon that anytime you are raising a case, you use the prefix whether or not or whether. Whether or not or whether. But please note that it depends on the writing style of the lecturer or the one demanding you to brief the case. After the legal issues, all that you need to do is to talk about the argument of the parties on each legal issue that arose in the case. The argument of the parties. So you do the argument for the plaintiff and you do that for the defendant. We move on to the holding of the court. And where we stated that with the holding of the court, it is a simple yes or no answer to the legal issues that has arisen in the case. Now we moved ahead to look at the ratio decidendi. And I said that there are 2 ways or 3 steps that leads to getting the ratio. First, the court or the judge will look at the material facts, looking at the material facts and look at the applicable laws and then apply the applicable laws to the material facts and get the ratio. Remember, the ratio is the reasoning of the court. It is the part of the ruling that has the binding effect that any other case that arises with similar facts and falls on all fours of the facts of this current case, or let's say the case we are talking about, the court will look at the ruling, the ratio of the court. Anytime your colleague asks you, what is this case about? What is the ratio of the court? Your friend or your colleague who is demanding the answer from you is only looking at you, sourcing out the material facts, using the applicable laws and applying it to the material fact to get the ratio of the court. Then we moved ahead to talk about the obiter. I said quote unquote. It is the non-fact bit of the case where judges, after giving the reasoning of the court, tend to also express their own opinion and others around the case. The last stage is the commentary session or the comment session where you yourself would have the opportunity to give your own opinion about the law or about the case, how you believe it should have gone or whether you agree with the ruling or others. Thank you very much for listening to me, and I'll be glad to meet you on our next episode. Like, subscribe, and share. Do comment as well, as we will be very grateful for your kind feedback. Just as I always say, do not leave all your matters to God. Take some to your lawyer. This is the Law Lab. Thank you.